Before we begin, a quick and important disclaimer. This video provides a historical analysis of the legal and social landscape of divorce in the 1990s and is intended for educational and entertainment purposes only. The information presented does not constitute legal, financial, or professional advice. Laws regarding domestic relations vary significantly by jurisdiction and have changed substantially since the decade in question. Viewers are strongly encouraged to conduct their own due diligence and consult with qualified legal counsel regarding any personal matters or modern legal proceedings. Imagine it is 1995. You are a professional in a mid-sized American city, and your marriage is ending. You walk into a wood-paneled law office, expecting a fair split and a fresh start. Instead, you are about to enter a decade described by legal scholars as the Great Transition, a period where the laws were modernizing, but the cultural biases of the 1950s were still firmly rooted in the judges' chambers. In the 1990s, a man's identity, his net worth, and his relationship with his children could be dismantled in a matter of months through a system that was effectively building the plane while flying it. We are talking about the era of the tender years doctrine's lingering ghost, the explosion of the no-fault fallout, and the birth of aggressive child support enforcement that changed the lives of millions of American fathers. If you think divorce is complicated now, you haven't seen the psychological and financial gauntlet that was the 1990s. This deep dive masterclass is designed to pull back the curtain on the specific historical trends that shape the modern American male experience in the family court system. By understanding the precedents set during this decade, you will gain a profound understanding of why the current system operates the way it does. We are going to examine the actual case studies of men who navigated the shift from sole provider status to non-custodial parent, the hidden impact of the 1992 Bradley Amendment, and the specific ways that asset division shifted as the dot-com bubble began to inflate. This is the definitive history of the 1990s divorce, providing you with the context that most modern legal summaries completely overlook. The 1990s represented a unique paradox in American history. On one hand, the no-fault revolution, which had begun in California in 1969, had finally saturated nearly every state in the Union. On the other hand, the societal expectation of the father as a secondary, visitation-only figure remained the default setting for many family court judges who had been practicing since the 1970s. This created a friction point. Men in the 90s were the first generation of fathers who were actively encouraged to be involved and emotionally present during the marriage, yet they faced a legal system that often viewed them primarily as a paycheck once the marriage dissolved. To understand the 1990s landscape, we have to look at the statistical reality of the time. The divorce rate had leveled off from its 1981 peak, but it remained historically high. For a man entering a courtroom in 1992, the potential outcomes were heavily influenced by the primary caretaker rule. This was the decade where the tender years doctrine, the legal presumption that mothers are naturally better suited to care for young children, was officially being phased out in writing but remained the unspoken law of the land. In practice, this meant that unless a father could prove a mother was unfit, a high legal bar involving documented evidence of neglect or endangerment, his chances of gaining primary physical custody were statistically slim. Most men were funneled into what was known as standard visitation, every other weekend and one weeknight dinner. This every other weekend model was more than just a schedule. It was a cultural phenomenon that defined a decade of fatherhood. We see this reflected in the media of the time, from films like Mrs. Doubtfire to Liar Liar, which depicted fathers as desperate outsiders fighting against a rigid, often bureaucratic system to maintain a connection with their children. These weren't just Hollywood tropes. They reflected the historical trend of the 1990s where the legal system prioritized stability by keeping children in one home, which, more often than not, meant the father became a visitor in his children's lives. Financially, the 1990s introduced a new level of complexity through the federalization of child support. Before this era, child support was often handled with a significant amount of judicial discretion, leading to wild inconsistencies. However, the Family Support Act of 1988 began to take full effect in the early 90s, requiring states to use specific formulas and guidelines. While this was intended to create fairness, for many men, it created a cliff effect. These formulas were often based on gross income rather than net, and in an era where the cost of living was rising but the secondary household costs for fathers were ignored, many found themselves in a state of working poverty. A critical, often overlooked piece of 1990s history is the Bradley Amendment. While passed in 1986, its full weight was felt by men in the 1990s. This federal law prohibited the retroactive reduction of child support arrears. If a man lost his job in the 1991 recession, his child support debt continued to mount. Even if he eventually went back to court to lower his payments, the judge was legally barred from reducing the debt that had already accumulated. This led to thousands of case studies where men entered the 21st century with phantom debt that was legally impossible to discharge, even in bankruptcy. Furthermore, the 1990s saw a massive shift in how assets were divided. We were moving away from a world of simple home equity and into a world of complex 401k plans, stock options, and intellectual property. The Qualified Domestic Relations Order, or QDRO, became a standard, yet terrifyingly complex, tool in the divorce lawyer's arsenal. Men who had spent the decade building a career in the burgeoning tech or finance sectors suddenly found that their future retirement was being sliced in half by formulas that didn't always account for the tax implications of those withdrawals. The psychological landscape was equally grueling. The 90s was the decade of the self-help boom, but much of that advice was aimed at women finding their voice after divorce. For men, the social script was still grin and bear it. There were very few support groups for divorced fathers, and the stigma of being a divorced man still carried a weight of perceived failure in the corporate world. You were expected to move into a bachelor apartment, stay focused on your career, and pay your obligations without complaint. The concept of parental alienation was only just beginning to be discussed in academic circles and was rarely recognized in the courtroom, leaving many men without a vocabulary to describe the emotional distancing they were experiencing with their children. By the mid-1990s, we also saw the rise of domestic violence as a tactical element in high-conflict divorces. While the Violence Against Women Act of 1994 was a landmark piece of legislation for genuine protection, the decade also saw a rise in the use of temporary restraining orders as a first-strike maneuver in custody battles. Because these orders could be granted ex parte, meaning without the other party present, a man could find himself removed from his home and barred from seeing his children before he even knew a divorce had been filed. This silver bullet strategy became a hallmark of the 1990s legal playbook, creating a climate of fear and defensiveness that defined the era's litigation style. In this series, we are going to break down every one of these elements. We will look at the specific tax codes of the mid-90s that influenced alimony, then called maintenance, and how the permanent alimony awards of that era are still being paid by some men today. We will examine the step-by-step process of a 1996 custody evaluation and show you exactly how the psychological testing of that era was biased against the male communication style. This isn't just a history lesson. It's a deep dive into the DNA of the American family court system. By the end of this 10-part masterclass, you will understand the 1990s divorce experience better than the people who actually lived through it. We are going to explore the data, the laws, and the lived realities that turned the 1990s into a crucible for the American father. To understand the mechanics of a 1990s divorce, you have to understand the sheer weight of the no-fault paradox. Imagine a man named Michael in 1994. Michael is a project manager in Chicago. He has been married for 12 years, has 2 children, and has spent the last decade assuming that if he worked hard and provided, his family unit was secure. One Tuesday evening, he is served with papers. In the 1990s, the no-fault system meant that Michael's wife did not need to prove adultery, cruelty, or abandonment. She simply had to cite irreconcilable differences. For men like Michael, this felt like the legal equivalent of having the rug pulled out from under a finished house. The historical trend here was a shift from divorce as a punishment for bad behavior to divorce as a unilateral administrative process. But while the entry into divorce was streamlined, the exit, the division of a life, was anything but simple. Michael enters the discovery phase, which in the 1990s was a paper-heavy nightmare. There were no cloud-based document portals or digital banking archives. Lawyers in 1994 relied on physical subpoenas and boxes of carbon copy bank statements. This phase was where the financial hemorrhaging began. Every hour a paralegal spent digging through shoe boxes of receipts was an hour billed at a premium. For men in the 90s, the discovery phase often felt like a forensic audit of their entire adulthood. The legal system was transitioning into valuing non-tangible assets, and this is where Michael hits his first major hurdle: the valuation of his professional license and future earning capacity. In several high-profile case studies from the mid-90s, courts began to treat a husband's career advancement during the marriage as a marital asset. If Michael had earned his MBA while married, a 1990s judge might determine that his wife was entitled to a portion of the projected lifetime value of that degree. This wasn't just about splitting the savings account. It was about placing a lien on Michael's future. The logic was that the spouse had supported the household while the degree was earned, and therefore, the degree was a joint investment. For a man in 1994, this meant he wasn't just losing half of what he had. He was potentially losing a percentage of what he hadn't even earned yet. Now let's look at the housing market of the mid-90s. Interest rates were hovering around 7% to 8%. A significant drop from the 80s, but still high enough to make refinancing a burden. In the 1990s, the standard procedure was to award the marital home to the custodial parent, usually the mother, to maintain stability for the children. Michael, like many men of his era, was forced to move into a rental or a smaller condo while still being responsible for a portion of the mortgage, or at the very least, seeing his equity locked away until the youngest child turned 18. This created a liquidity crisis for the 1990s father. He was often asset-rich on a balance sheet but cash-poor in his daily life, struggling to furnish a second home that was suitable for his weekend visitations. The visitation schedule itself was a masterpiece of 1990s rigidity. We have to look at the standard order of visitation. If Michael lived in a state like Texas or Ohio in 1995, his schedule was likely dictated by a pre-printed form. This usually granted him the first, third, and fifth weekends of every month. While this sounds organized, it created a structural barrier to actual parenting. Michael wasn't there for the Tuesday night homework, the Wednesday soccer practice, or the Thursday morning rush. He became the Disney dad, a term coined in the 90s to describe fathers who, having only 48 hours of time, overcompensated with gifts and trips because they were stripped of the mundane, essential moments of fatherhood. This leads us to the specific data regarding the psychological impact of the 1994 custody evaluations. In the mid-90s, the use of the Minnesota Multiphasic Personality Inventory, or MMPI-2, became standard in contested cases. Michael would be sat in a room and asked 5, 6, 7 true or false questions. The problem, as highlighted by contemporary historical analysis, was that the normal range for these tests was often calibrated in ways that could interpret a father's natural stress, anger, or defensiveness during a divorce as a permanent personality defect. If Michael was angry that his access to his children was being restricted, the test might flag him for high levels of authority conflict or hostility, which a jail, a guardian ad litem, would then use to recommend supervised visitation or restricted overnights. The role of the guardian ad litem in the 1990s cannot be overstated. These were often attorneys or social workers appointed by the court to represent the best interests of the child. However, in the 90s there were very few standardized guidelines for what best interests actually meant. It was highly subjective. If Michael's JL had a personal bias toward maternal care, Michael was fighting an uphill battle. He had to prove not just that he was a good father, but that he was an exceptional one, whereas the maternal role was often legally presumed to be sufficient. The financial pressure was compounded by the 1990s approach to temporary orders. Within 30 days of filing, a judge would hold a hearing to set the status quo. In many 1990s jurisdictions, these temporary hearings lasted only 15 to 20 minutes. In that short window, Michael's temporary child support and alimony were set. Because these were temporary, judges often leaned toward higher payments to ensure the children were taken care of until a final trial, which could be 2 years away. For Michael, those 2 years of temporary payments often became the baseline for the final order. If he managed to pay them by working overtime or draining his 401k, the court saw that as proof that he could afford that level of support indefinitely. It was a trap of his own competence. As the decade progressed, the 1997 Adoption and Safe Families Act added another layer of pressure, emphasizing the speed of permanency. This meant that if a father was pushed out of the picture early in the process, the window to re-establish himself as a primary caregiver was closing faster than ever before. Men in the late 90s were navigating a system that was increasingly focused on efficiency over nuance. The rocket docket was born, and if your lawyer wasn't aggressive enough in the first 90 days, the trajectory of your next 18 years was effectively set in stone. But what happened when the money ran out? In the 1990s, the deadbeat dad narrative was at an all-time high in the American zeitgeist. The Clinton administration made child support enforcement a centerpiece of federal policy. In 1996, the Personal Responsibility and Work Opportunity Reconciliation Act was passed. This gave states the power to revoke driver's licenses, professional licenses, and even passports of men who fell behind on support. For Michael, if his project management job was phased out in the 1998 market shifts, He faced the very real potential outcome of losing his ability to drive to job interviews because he couldn't pay for the children he wasn't allowed to see. This was the 1990s gauntlet, a high-stakes combination of shifting social norms, rigid legal formulas, and a cultural narrative that often viewed fathers as optional extras. But as the decade drew to a close, a new movement began to stir. Fathers started to organize. They started to challenge the MMPI2 results and the every other weekend status quo. They began to demand joint legal custody, a concept that existed on paper but was rarely practiced in earnest until the late 90s. However, just as men were beginning to gain some ground in the custody wars, a new financial weapon was being perfected in the courtrooms of the 1990s. It wasn't about the house or the car. It was about the lifestyle maintenance. In the next part, we are going to look at the rise of standard of living alimony and how the 1990s created a system where a man could be required to fund a life he was no longer allowed to live. We will dive into the specific case of a high-earning executive in 1997 who found himself living in a studio apartment while his ex-wife remained in their 5-bedroom estate, all legally mandated under the guise of equitable distribution. You won't believe how the math was actually calculated. To understand the math of the mid to late 1990s, you have to look at the transition from needs-based alimony to lifestyle-based maintenance. Imagine a man named David in 1997. David is a senior executive at a rising telecommunications firm in Northern Virginia. He earns $300,000 a year, which in 1997 puts him in the upper echelon of American earners. When his 20-year marriage ends, the court doesn't just look at what his wife, Sarah, needs to survive. They look at the standard of living established during the marriage. This was the decade where the phrase lifestyle maintenance became a weapon of financial attrition. The court's logic was that Sarah should not have to experience a significant drop in her quality of life simply because the marriage ended, even if David's post-divorce income couldn't realistically support 2 households at that same elite level. The calculation was a brutal 3-step process. First, the court would perform a historical lifestyle audit. In 1997, this involved a line-by-line review of credit card statements from the previous 3 to 5 years. Every country club membership, every European vacation, and every high-end grocery bill was tallied to create a monthly burn rate. For David, this burn rate was $20,000 a month. Step 2 was determining Sarah's earning capacity. Even if Sarah had been out of the workforce for 15 years, the court might impute an income to her. But in the 90s, this was often a nominal amount based on entry-level clerical work. If the court decided Sarah could realistically earn $2,000 a month, David was on the hook for the $18,000 deficit. The third step was the most devastating: the duration. In the 1990s, many states still adhered to the rule of thumb that a marriage lasting longer than 10 or 15 years qualified for permanent alimony. This didn't mean until Sarah got a job or until David retired. It meant until Sarah remarried or either party died. For a man like David, this created a scenario where he was effectively working for his ex-wife for the rest of his life. Historical trends from this era show that men in David's position often found themselves in a financial paradox. He was legally required to maintain the 5-bedroom estate in Great Falls for Sarah and the children, including the mortgage, property taxes, and maintenance, while he moved into a 2-bedroom corporate rental. On paper, David was a high earner. In reality, after federal taxes, state taxes, lifestyle maintenance, and child support, his discretionary income was lower than that of his junior associates. This brings us to the specific 1990s phenomenon of the double dip. This was a legal strategy often used when the husband owned a professional practice or a small business. Let's look at the case study of a specialized surgeon in 1998. The court would value his medical practice as an asset and award the wife half of that value in the property split. Then, the court would look at the income generated by that same practice to calculate alimony. In effect, the man was paying for the business twice, once as a lump sum or structured payout of the asset's value, and a second time as the source of his ongoing support obligations. This era of the double dip was one of the most litigated and controversial aspects of 1990s family law, leading to a decade of appeals that eventually changed the laws in many states, but not before thousands of men were liquidated by the math. Beyond the alimony, we have to talk about the 1990s tax trap. Before the 2017 tax reforms, alimony was tax-deductible for the payer and taxable for the recipient. While this sounds like a benefit for the man in the high-inflation, high-growth environment of the late 90s, it often pushed the payer into a lower but still substantial tax bracket while the legal fees remained non-deductible. Men were writing checks for $10,000 a month in maintenance, But they were also paying $50,000 a year in non-deductible legal fees to defend against motions for increases in that maintenance. In 1999, if David's company went public and he received a windfall of stock options, his ex-wife's legal team would immediately file a motion for a modification of support based on a material change in circumstances. The 1990s was the decade where a man's success was instantly shared, but his financial losses were his alone to bear. Consider the 1990s approach to the marital home. In 2026, we often see houses sold and proceeds split. But in 1996, the house was a pawn. A common potential outcome for men was the deferred sale of the marital home. The court would grant the wife exclusive use of the home until the youngest child graduated high school. David would be responsible for half the mortgage and all major repairs, but he had no access to his equity for perhaps a decade. If the roof leaked in 1997, David paid. If the HVAC failed in 1998, David paid. He was a silent partner in a real estate investment that provided him no shelter and restricted his ability to qualify for a mortgage on a new home for himself. This created a generation of men who felt like ghosts in their own lives, paying for the light bills in rooms they weren't allowed to enter. Then there was the issue of the 1990s life insurance mandates. To secure the alimony and child support, judges would frequently order men to maintain massive life insurance policies with the ex-spouse as the irrevocable beneficiary. In David's case, he might be ordered to carry a $3 million term policy. If he became uninsurable due to the stress-related health issues that often accompany high-conflict divorce, he was technically in contempt of court. This added a layer of existential anxiety. A man's value was quite literally higher to his estate if he were dead than if he were alive and struggling to keep up with the payments. The 1990s also saw the peak of the vocational expert. This was a professional hired by the husband's legal team to prove that the wife was capable of earning more than she claimed. This led to absurd courtroom battles where experts would debate the 1997 job market for a woman who hadn't used a computer since the 1980s. The husband would spend $5,000 on an expert to prove the wife could earn $30,000 a year, only for the judge to split the difference and award the higher maintenance anyway. It was a decade of expensive, granular battles that rarely moved the needle in the father's favor. But the financial gauntlet was only half the story. While the money was being carved up, a much more silent and devastating process was happening in the background: the psychological restructuring of the 1990s family. This was the era where the term parental alienation began to surface in the basement of courthouses, even if it hadn't yet reached the judge's bench. Men were finding that as the financial orders became more burdensome, their access to their children became more restricted, often through subtle, non-legal means. If you think the financial split was calculated, wait until you see how the 1990s legal system handled the relocation of children. In the next part, we are going to dive into the era of the move-away case. We will look at how a man could be paying top-tier support for children who were suddenly allowed to move 2,000 miles away, effectively ending his physical relationship with them. We will examine the 1990s case studies that set the precedent for why, even today, a father's proximity to his children is often treated as an afterthought by the court. The math was bad, but the geography was worse. The 1990s introduced a legal phenomenon that shattered the traditional concept of joint parenting: the rise of the relocation or move-away case. Imagine a man named Robert in 1998. Robert is a middle manager in Denver, Colorado. He has finally settled into his post-divorce life. He has a modest apartment 3 miles from his ex-wife. He has been diligent with his every other weekend schedule, and he hasn't missed a single Tuesday night dinner with his 7-year-old son. Then he receives a certified letter. His ex-wife has been offered a job, or perhaps she has met someone new, and she intends to move with their son to Charlotte, North Carolina, nearly 1,600 miles away. In the mid-90s, the legal standard for such a move was heavily weighted in favor of the custodial parent, creating a geographic displacement that essentially turned active fathers into long-distance pen pals. Historically, the 1996 California Supreme Court case of Burgess was a watershed moment that echoed across the United States. It established a trend where the custodial parent had a presumptive right to change the residence of the child, as long as the move wasn't proven to be specifically intended to prejudice the non-custodial parent's rights. For Robert, this meant that the burden of proof was entirely on his shoulders. He had to prove that the move would be detrimental to the child. In a 1990s courtroom, simply saying "I will lose my relationship with my son" was often seen as a secondary concern compared to the custodial parent's right to pursue a better life or a higher-paying job. The court's logic was that what is good for the custodial parent is inherently good for the child, a philosophy that ignored the biological and psychological necessity of the father's presence. When these moves were granted, the potential outcomes for men like Robert were devastatingly logistical. The court would replace the every other weekend schedule with a long-distance plan. This usually meant the child would spend the entire summer, and perhaps every other Christmas with the father. While this looks like a significant block of time on a calendar, it effectively stripped the father of his role as a parent and replaced it with the role of a camp counselor. Robert would no longer be there for the school plays, the emergencies, or the quiet Tuesday nights. He was now responsible for the immense costs of airfare in an era before discount travel sites were ubiquitous. In 1998, flying a child across the country 8 times a year was a massive financial burden that the court often ordered the father to pay for, in addition to his standard child support. This geographic separation created a fertile ground for what experts in 2026 recognize as the erosion of the paternal bond. In the 1990s, communication was limited to landline telephones and the occasional expensive long-distance call. There was no video conferencing, no instant messaging, and no digital sharing of school projects. If Robert called at 7 p.m. to say goodnight, and the phone wasn't answered, his connection to his child was effectively severed for the day. This era saw a significant historical trend of drift, where fathers, overwhelmed by the pain of the distance and the logistical hurdles of the long-distance schedule, slowly became less involved. The system didn't just allow for this. In many ways, the rigid move-away laws of the 90s facilitated it. Let's look at the step-by-step reality of a 1999 relocation hearing. First, the move-away study. A court-appointed evaluator would interview both parents. If the mother claimed the move was for a $10,000 raise, the evaluator would often check that box as a valid reason. For the father, the evaluator would ask, "Can you move too?" For many men, tied to specific regional jobs or unable to afford the move due to alimony and child support obligations, the answer was no. The evaluator would then conclude that the child's stability was best served by staying with the primary caretaker, regardless of the distance. This was the era of the portable child, where the legal system viewed children as attachments to the mother, rather than independent beings with the right to both parents. This leads us into the darker corner of 1990s litigation, the rise of high-conflict expert witnesses. Because move-away cases and custody battles were becoming so complex, a new industry of forensic psychologists emerged. In 1995, a man might find himself paying $500 an hour for a psychologist to observe him playing with his children in a sterile office for 60 minutes. This observation would then be turned into a report that could determine his future for the next decade. Case studies from this era show that these evaluations were often highly subjective. If a father was too firm, he was labeled as rigid. If he was too playful, he was labeled as lacking parental authority. It was a psychological tightrope where the rules were never clearly explained to the man until he had already fallen off. Furthermore, we must examine the 1990s trend of domestic torts. As if the divorce itself wasn't enough, some legal teams began filing separate civil lawsuits against husbands during the divorce process. Imagine if Robert's ex-wife sued him for intentional infliction of emotional distress based on arguments that occurred during the marriage. This meant Robert was fighting a war on 2 fronts: the family court for his children and the civil court for his remaining assets. While these suits were often dismissed, they served a tactical purpose: to drain the father's financial reserves and force him into a lopsided settlement just to make the litigation stop. It was a decade of legal scorched earth. The 1990s also saw the introduction of mandatory mediation in many states. On the surface, this was designed to reduce conflict. However, for a man in 1997, mediation often felt like a high-pressure sales tactic. Mediators, often overwhelmed with massive caseloads, would push for the standard visitation schedule because it was the easiest to process. If a man wanted 50-50 custody, which was rare and controversial at the time, he was often told by his own mediator that he was being unrealistic and that a judge would never grant it. This forced many men to sign away their parental rights in a windowless conference room, believing they had no other choice. To add another layer, we have to look at the 1990s cultural obsession with the super predator and the dangerous male narrative. This cultural backdrop bled into the family courts, where any accusation of anger or instability against a father was taken with extreme gravity, often without the need for corroborating evidence. A single heated argument during a 1996 separation could be characterized in court as a history of violence, leading to supervised visitation orders that could take years to overturn. The father was often forced to attend anger management classes, not because he was violent, but as a precautionary measure that he had to pay for out of pocket. The cumulative effect of these relocation laws, forensic evaluations, and tactical civil suits was a state of total exhaustion for the 1990s father. By the time the final decree was signed, many men were financially ruined and emotionally shattered. But there was one final trap waiting at the end of the decade: a shift in how the government looked at a man's very identity. As we moved toward the year 2000, the digital age began to track men in ways they never anticipated. In the next part, we are going to look at the birth of the digital surveillance state and family law. We will explore how the late 90s saw the creation of the National Directory of New Hires, and how the government began using automated systems to track every paycheck a man earned to ensure the state got its cut. We will also dive into the terrifying trend of imputed income, where a judge could decide you were underemployed and order you to pay support based on a job you didn't even have. This was the moment the 1990s divorce stopped being about the family and started being about the state's bottom line. You won't believe the lengths the government went to in 1999 to turn fathers into line items on a spreadsheet. As we crossed the threshold into 1999, the American divorce landscape underwent a digital transformation that fundamentally altered the relationship between a father, his income, and the state. This was the era where the National Directory of New Hires became a reality. Imagine a man named Stephen in 1999. Stephen is a skilled carpenter in Ohio who has just finalized a difficult divorce. He decides to move to a new city for a fresh start and lands a job with a construction firm. In the 1980s, it might have taken months or even years for a child support order to catch up with a parent across state lines or even between different employers. But in 1999, the moment Stephen hands over his social security number to his new HR department, an automated system flags his name. Within weeks, his new employer receives a wage withholding order. This wasn't just about efficiency. It was the birth of a surveillance-style enforcement that treated every divorced father as a high-risk debtor. This federalization of tracking was bolstered by the 1996 Welfare Reform Act, but its full technical implementation reached its peak at the very end of the decade. For men like Stephen, there was no longer a transition period between jobs. The historical trend shifted toward immediate and absolute wage garnishment. In many cases, Stephen wouldn't even see his full paycheck. The state would take its cut before the funds ever hit his bank account. This created a profound psychological shift. A man's paycheck was no longer his own. He was essentially a middleman between his employer and the state's collection agency. The data from this period shows that while collection rates went up, the sense of autonomy for fathers plummeted. But the most controversial financial mechanism of the late 90s was the concept of imputed income. This is a crucial area of the 1990s masterclass because it represents a move from reality-based law to speculative-based law. Imagine if Stephen, exhausted from the physical toll of carpentry and the emotional weight of his divorce, decided to take a lower-paying, less stressful job at a local hardware store. In a 1999 courtroom, the judge could look at Stephen's previous tax returns and decide that he was voluntarily underemployed. The court would then impute income to him, meaning they would calculate his child support based on what they believed he could or should be earning, rather than what he was actually making. The step-by-step logic used by judges during this time was often detached from the actual job market. A vocational expert would testify that based on Stephen's age, health, and experience, he had the capacity to earn $60,000 a year. Even if Stephen couldn't find a job at that salary in his new town, the judge would set the support order at the $60,000 level. This created a scenario where Stephen was legally required to pay money he didn't have. If he failed to meet the obligation based on this phantom income, he would fall into arrears. In the late 90s, these arrears were subject to high interest rates, sometimes as high as 10% or 12% annually, and as we discussed with the Bradley Amendment, they could never be forgiven or reduced. This was how the system turned a temporary career change into a lifetime of inescapable debt. Another layer of this 1999 financial architecture was the health insurance mandate. Men were often ordered to provide health insurance for their children, regardless of whether their employer offered an affordable plan. If Stephen's new job didn't offer insurance, he was expected to purchase a private policy on the open market. In the late 90s, before the existence of modern healthcare exchanges, private insurance was prohibitively expensive. Stephen could find himself paying $800 a month for child support and another $400 for a private health plan, all while living in a studio apartment and eating ramen. If he failed to provide the insurance, he was in contempt of court which could lead to the revocation of his driver's license. Let's look at the specific case study of a software engineer in 1999. He loses his job during the early ripples of the dot-com bubble burst. He goes to court to ask for a reduction in support. The court tells him he must first prove he has applied for at least 20 jobs a week for the last 3 months. Even with this proof, the judge might only grant a temporary reduction for 90 days, after which the payments revert to the original amount, regardless of his employment status. This created a high-stakes environment where a man's financial survival was tied to market forces he couldn't control, while his legal obligations remained static and unforgiving. We also have to address the 1990s approach to the 401k and the Qualified Domestic Relations Order, or QDRO. By 1999, the 401k had replaced the pension as the primary retirement vehicle for most American men. In a divorce, these accounts were split down the middle. However, the process of splitting them was a bureaucratic labyrinth. Stephen would have to hire a specialized attorney just to draft the QDRO. If the paperwork had a single comma out of place, the plan administrator would reject it, leading to more legal fees. Many men in the late 90s saw their retirement accounts drained not just by the split itself, but by the thousands of dollars in fees required to legally execute that split. Furthermore, if the market dipped between the time of the agreement and the actual transfer of funds, a common occurrence in the volatile 1999 market, the man often had to make up the difference in cash to ensure the ex-spouse received the exact dollar amount promised in the decree. The decade concluded with a society that was increasingly comfortable with the state as a third party in the family unit. The Internal Revenue Service also played a role. The 1990s was the era where the dependency exemption became a major bargaining chip. In 1998, the law generally awarded the tax exemption for the children to the custodial parent. For a father like Stephen, losing the ability to claim his children on his taxes meant he was paying more in federal taxes, while also paying out a significant portion of his income in support. To get that exemption back, he had to negotiate it in the divorce decree, often having to trade away other assets or accept higher alimony just to get a basic tax break. This period was the absolute peak of the spreadsheet divorce. Every aspect of a man's life, his potential for growth, his future retirement, his tax status, and his very ability to hold a job, was quantified and codified. The system was designed for maximum extraction to ensure that the state never had to step in with welfare payments. The father became the ultimate insurance policy for the government. The emotional cost was treated as an external factor, something that didn't fit into the cells of the state's automated tracking software. But as the clock ticked toward the year 2000, something began to break. The sheer weight of these financial and geographic pressures led to a mental health crisis among divorced men that the 1990s was completely unequipped to handle. The strong, silent expectation of the previous generation was colliding with the financially liquidated reality of the new one. Men were reaching their breaking point, and the legal system was about to face a reckoning regarding the actual human cost of its efficiency. In the next part, we are going to look at the psychological toll of the 1990s divorce. We will examine the historical trends in male suicide rates and depression during this decade, and how the lack of social support systems created a lonely man epidemic. We will also dive into the rise of the pro-se litigant men who, having been bankrupt by the system, began to represent themselves in court, leading to a chaotic clash between raw human emotion and cold legal procedure. This was the moment where the masterclass moved from the wallet to the psyche, and the results were more tragic than anyone realized at the time. What happens when a man has nothing left to lose but his voice? We find out next. The psychological toll of the 1990s divorce on men was a silent crisis that lacked the vocabulary of modern 2026 mental health awareness. To understand this, imagine a man named James in 1996. James is a middle-aged veteran of a 15-year marriage who has just been ordered to vacate his home. In the 1990s, the concept of male vulnerability was culturally suppressed. The predominant historical trend was the expectation that a man should simply pick up the pieces, work harder, and remain stoic. However, the data from this decade tells a far grimmer story. Research into male suicide rates during the 1990s showed a significant correlation between divorce and a heightened risk of self-harm, with some studies suggesting that divorced men were up to 8 times more likely to take their own lives than married men. For James, the loss wasn't just a financial split. It was a total collapse of identity. In 1996, James found himself in a world that provided almost no specialized support for men in his position. There were no online forums, no podcasts, and very few local support groups that didn't feel like an extension of the legal system. This isolation was compounded by the loss of his social circle. In the 1990s, the marital social network was often centered around the wife's organizational efforts or the children's school activities. When the marriage ended, James didn't just lose a spouse. He lost his church community, his neighborhood friendships, and even his connection to extended family members who felt forced to choose sides. This social liquidation left many men in a state of chronic loneliness that exacerbated the depression triggered by the legal proceedings. The concept of the disenfranchised griever perfectly describes the 1990s experience for men. Because society viewed divorce as a liberated choice or a necessary legal transaction, the profound grief men felt over the loss of their daily connection to their children was often dismissed. If James expressed sadness about missing his daughter's bedtime stories, he was told to stay busy or focus on his career. This dismissal led to what psychologists now call the father wound of the 90s. The psychological weight of being a visitor in one's own children's lives created a sense of perpetual mourning. Every other weekend visitation felt like a temporary bandage on a deep, structural laceration. As James navigated the late 90s, he likely encountered the rise of the pro se litigant. By 1997, legal fees had reached such an astronomical level, often ranging from $200 to $400 an hour, that many men simply ran out of money. James was forced to walk into a courtroom without an attorney, facing a seasoned legal team on the other side. This was a clash of raw human emotion against cold, procedural efficiency. The step-by-step reality for a pro se man in 1998 was a nightmare of paperwork. He had to learn the rules of evidence, the proper way to file a motion, and the technicalities of cross-examination on the fly. When he inevitably failed to follow a procedural rule, the judge would often show little patience, viewing his emotional pleas as irrelevant to the legal facts. This powerlessness in the face of the state led to a profound sense of institutional betrayal. This sense of betrayal was further fueled by the historical trend of therapeutic jurisprudence, which emerged in the late 90s. While intended to help families, it often meant that James was ordered by the court to attend therapy or parenting classes. However, these programs were frequently designed with a one-size-fits-all approach that didn't account for the specific needs of grieving fathers. If James sat in a court-mandated class and expressed anger at the system, his anger was documented by the facilitator and reported back to the judge as evidence of his unsuitability for joint custody. It was a closed loop where the natural emotional response to a high-stress situation was used as a weapon to further restrict his parental rights. Furthermore, we must examine the impact of 1990s workplace culture on the divorced man. This was an era of intense corporate competition and the rise of the 70-hour work week. James was expected to maintain his productivity to pay his soaring support obligations, yet he was also expected to be available for his limited visitation times. If he asked for flexibility at work to attend a school event, he was often viewed as less committed to his career than his married or single peers. Men in the 90s were caught in a vice between a legal system that demanded their money and a corporate system that demanded their time, leaving almost no room for their own emotional recovery. Case studies from the late 90s also highlight the phenomenon of the transitional relationship. To combat the crushing loneliness, many men like James rushed into second marriages or new partnerships far too quickly. In the 1990s, the rebound was a standard coping mechanism. However, without having processed the trauma of the first divorce, these men often carried the same patterns and legal vulnerabilities into the next relationship. This led to the tragic historical trend of serial divorce, where the financial and emotional depletion was doubled, often leaving the man in a state of total permanent insolvency by the time he reached his 50s. The internal psychological landscape was also altered by the 1990s obsession with closure. Men were told they needed to get over it and move on, but the legal system ensured they never could. With child support and alimony payments stretching into the 21st century, the 1990s divorce was a wound that was kept open by a monthly check. Every time James wrote that check, he was reminded of the failure of his marriage and the restrictions on his fatherhood. It was a form of financial and emotional tethering that prevented any true psychological detachment from the conflict. The lack of 1990s resources for men even extended to the physical realm. This was the decade where we began to see the divorce stress health decline in men. The data suggests that divorced men in this era suffered from higher rates of cardiovascular disease, hypertension, and immune system suppression. James wasn't just mentally exhausted. His body was reacting to the sustained cortisol levels of a years-long legal battle. Without a support system to encourage healthy habits or provide emotional outlets, many men turned to alcohol or overwork, further degrading their physical and mental health. By the time 1999 arrived, the lonely man epidemic was a full-blown societal issue, though it remained largely unaddressed by mainstream media. The fathers who had been liquidated by the 1990s system were now a significant demographic, men living in temporary housing, working multiple jobs, and navigating a world where they felt their primary value was their ability to generate income for others. The psychological toll had moved from an individual struggle to a collective cultural trauma for a generation of American fathers. But as these men reached their breaking point, they began to look for new ways to fight back. They weren't just going to be silent anymore. They started to look at the very laws that had been used against them and began to formulate a new strategy for the new millennium. This wasn't about anger, it was about the survival of the paternal bond. In the next part, we are going to look at the rise of the fathers' rights movement in the late 90s. We will examine the high-stakes protests, the legislative lobbying, and the first major legal victories that began to crack the tender years foundation of the family court. We will dive into the specific case of a group of men in 1999 who staged a dramatic demonstration that finally forced the media to look at the man behind the child support check. The resistance was beginning, and it was going to change everything. The resistance that began to solidify in 1999 was not a sudden explosion but a slow-motion pressure cooker reaching its limit. To understand the shift, imagine a man named Thomas in late 1998. Thomas is a civil engineer who has spent the last 3 years following every court order to the letter, yet he has seen his parenting time systematically whittled down to a handful of hours per month. In the 1990s, men like Thomas were often told by their own lawyers to stay quiet and not make waves. But by the end of the decade, a historical trend emerged where fathers began to realize that their silence was being interpreted by the court as acquiescence. This realization birthed the modern era of fathers' rights advocacy, a movement that shifted from private grief to public, coordinated protest. One of the most significant case studies of this era involves the rise of grassroots organizations that began to utilize the early internet to organize. In 1999, Thomas might have found a primitive web forum where men from across the country were sharing their experiences. This was a revolutionary moment. For the first time, a father in Maine could compare his custody decree with a father in California and realize that the every other weekend standard was not an act of God, but a systemic legal policy. These men began to organize rallies at state capitals. They didn't just carry signs, they brought data. They pointed to the increasing body of psychological research suggesting that children with two actively involved parents showed better potential outcomes in terms of academic performance and emotional stability. However, the legal establishment in 1999 was incredibly resistant to this push. When Thomas and his peers began to demand shared parenting, defined as a 50-50 split of time, they were met with the argument that such arrangements would create too much conflict for the child. The potential outcomes of these early legislative pushes were often minimal at first, but they planted the seeds for the rebuttable presumption of joint custody. Before this movement, a father had to prove why he should have time. The goal of the 1999 activists was to flip the script, forcing the court to start with the assumption that both parents are equal and requiring the state to prove why one should have less. Step by step, these organizations began to target specific, antiquated laws. They looked at the 1990s implementation of the best interests of the child standard and argued that it was being used as a blank check for judicial bias. In 1999, a group of fathers in the Northeast famously occupied a family court building, not with violence but with a sit-in, demanding a meeting with the chief judge to discuss the lack of enforcement for visitation interference. This was a key turning point. While the state was incredibly efficient at using the National Directory of New Hires to track down a father's paycheck, it was notoriously slow to act when a mother blocked a father's scheduled weekend. Thomas found that if he missed a payment, he faced jail. If his ex-wife missed a visitation handoff, she faced a stern warning at most. This double standard became the rallying cry of the late 90s movement. The movement also began to challenge the financial math we discussed in earlier parts of this masterclass. They started lobbying for what became known as the income shares model. In the mid-90s, many states used a percentage of obligor model, which only looked at the father's income. By 1999, several states were being pressured to adopt a model that looked at the combined income of both parents, and then divided the obligation based on the actual time the child spent with each. For a man like Thomas, this was a battle for basic mathematical fairness. He argued that if he had the children 40% of the time, His child support should reflect the direct costs he was already incurring for food, housing, and clothing during that time. We also have to examine the role of the 1990s media in this resistance. As the decade closed, news programs like 2020 and 60 Minutes began to run segments on the plight of the modern divorced father. These stories often featured case studies of men who were living in their cars while paying 60% of their gross income in support and alimony. This media coverage started to shift the public's characterization of the divorced man from a deadbeat to a victim of a rigid bureaucracy. While this didn't change the law overnight, it created the social permission for judges to begin experimenting with more equitable custody arrangements. Consider the historical trend of the legislative audit. In 1998 and 1999, several state legislatures commissioned studies to look at the effectiveness of their child support guidelines. These studies often revealed that the high support orders of the 90s were actually counterproductive, as they pushed men into the underground economy or caused them to lose their jobs due to the stress and license revocations. Thomas's advocacy group used this data to argue for a more holistic approach. They weren't just fighting for their own wallets. They were fighting for the ability to remain viable, productive members of society who could actually provide for their children in the long term. But the resistance wasn't just in the streets or the state houses. It was also happening inside the courtrooms through the rise of the father-friendly attorney. By 1999, a niche market had developed for lawyers who specialized in representing men. These attorneys began to use aggressive discovery tactics to uncover hidden income of the ex-spouse, or to challenge the subjective reports of the guardian ad litem. They brought in their own expert witnesses, psychologists who could testify to the importance of the paternal bond. For Thomas, hiring one of these specialized attorneys in 1999 was a high-stakes investment. It cost him his remaining savings, but it was the first time he felt like he had a shield instead of just being a target. This era also saw the first major pushback against the Bradley Amendment. While the law remained on the books, fathers' rights groups began to document the human toll of non-dischargeable arrears. They presented cases of men who had suffered catastrophic injuries or illnesses, but were still being billed for support they couldn't possibly pay. These case studies were instrumental in eventually creating hardship exceptions in some jurisdictions, though the fight against the absolute nature of the Bradley Amendment continues even in 2026. As 1999 drew to a close, the atmosphere in family courts across the United States was one of palpable tension. The system was still functioning on its 1990s autopilot of maternal custody and paternal payment, but the pilots were no longer in total control. The fathers who had been marginalized were now armed with data, legal representation, and a growing sense of collective identity. They were no longer just individuals going through a private tragedy, they were a constituency. However, just as this movement was gaining momentum, a new and unexpected challenge emerged that threatened to undermine the progress they had made. As we moved toward the new millennium, the very definition of a family was about to be reevaluated in a way that would complicate the father's rights narrative. In the next part, we are going to look at the rise of the blended family and the 1990s legal battles over step-parent rights. We will explore how a man could find himself paying for children that weren't biologically his, while still struggling to see his own. We will dive into the complex 1999 case of a man who was legally declared the father of a child he didn't conceive, simply because of a 1990s legal loophole called the presumption of paternity. The battle for the truth was just beginning. To fully grasp the absurdity of the legal landscape as the 1990s came to a close, we have to examine the ironclad nature of the presumption of paternity. Imagine a man named Mark in 1999. Mark has been separated from his wife for 2 years, though they never officially filed for divorce due to the high costs we have already discussed. During that separation, his wife has a child with another man. Under the laws of many states in the late 90s, because Mark was still legally married to her at the time of the birth, he was automatically listed on the birth certificate as the legal father. Even if DNA evidence, which was becoming more accessible by 1999, proved with 99.9% certainty that Mark was not the biological father, the law often valued the marital presumption over biological truth. For Mark, the potential outcomes were surreal. If he didn't challenge this presumption within a very strict, often 2-year window, he could be held legally responsible for child support for the next 18 years for a child that was not his. In the 1990s, the courts often used a logic known as the best interests of the child to justify this, arguing that the child deserved the financial support of a father figure, and that the state should not have to provide welfare if a legal husband was available to pay. This created a generation of trapped fathers, men who were financially tethered to the consequences of a relationship that had ended years prior. Mark was essentially being billed for his wife's move toward a new life. This leads us into the broader 1990s trend of the psychological and legal complexity of the blended family. By 1998, second and third marriages were common, but the legal system had not yet caught up to the reality of step-parenting. Imagine if Mark eventually did marry someone else, a woman who already had children of her own. He was now navigating a world where he was paying child support for his biological children from his first marriage, potentially paying support for a non-biological child from his first marriage due to the presumption loophole, and acting as a primary provider for stepchildren in his new home. The historical trend in the late 90s was that the court ignored the financial burden of the new family when calculating support for the old one. If Mark went to court in 1999 to ask for a reduction in support because he now had a new baby and 2 stepchildren to feed, the judge would likely tell him that his first family took precedence. The law viewed a man's decision to have a second family as a voluntary expense that should not detract from his original obligations. This created a phenomenon known as the second family squeeze. Men in the 90s were effectively being punished for trying to rebuild a stable home life, as the math simply didn't allow for the survival of both households. Furthermore, we must look at the specific 1990s battle over step-parent visitation. If Mark spent 5 years raising his second wife's children and then that marriage also ended in 1999, he generally had 0 legal rights to see those children. Despite the bond he had formed, he was legally a stranger. This was the decade where the term psychological parent began to gain some traction, but it was rarely enough to overcome the rights of a biological parent. Men were finding themselves in a revolving door of fatherhood, expected to provide for children while they were in the home, but discarded the moment the legal status of the relationship changed. Step by step, the 1990s legal system was deconstructing the traditional definition of fatherhood and replacing it with a series of contractual obligations. Let's look at the case study of a man in 1997 who discovered through a routine medical test that he was sterile and could not have biologically fathered the 10-year-old he had been raising. When he tried to stop the support payments during his divorce, the court ruled that because he had acted as the father for a decade, he was now equitably estopped from denying paternity. The court's priority was the continuity of the child's financial status, not the truth of the man's biological lineage. This era was the peak of biological irrelevance in the face of state-mandated financial stability. By 1999, the introduction of more sophisticated DNA testing started to create a massive backlog of paternity fraud cases. Groups of men began to lobby for paternity disestablishment laws. They argued that if a man could prove he wasn't the father, his support obligation should end immediately. However, the 1990s saw heavy pushback from state agencies who feared that if thousands of men stopped paying, the state's welfare burden would skyrocket. This created a high-stakes tug-of-war between individual rights and the state's bottom line. For every man like Mark who fought for the truth, there were a dozen others who simply accepted the debt because the legal fees to fight it were more expensive than the support payments themselves. The 1990s also introduced the complication of international relocation and blended families. As the workforce became more global toward the end of the decade, cases involving a parent moving a child to another country became a nightmare for fathers. The 1980 Hague Convention on the Civil Aspects of International Child Abduction was being tested like never before. If Mark's ex-wife decided to move to her native country in Europe or South America in 1998, Mark was facing a legal battle that could cost hundreds of thousands of dollars with no certain outcome. The 90s was the decade where a father's rights could literally vanish at a border crossing. To add even more depth to this masterclass, we have to look at how the 1990s system handled the death of a father. In many 1990s divorce decrees, a man's child support obligation didn't necessarily die with him. His estate could be held liable for the remaining years of support. If Mark had managed to save anything in a life insurance policy or a small inheritance for his second family, his first wife could place a claim on those funds to ensure the support for the first family was paid in full. This was the ultimate extraction, a system that followed a man even into the grave to ensure the state's mandates were met. The cumulative effect of these paternity laws, the second family squeeze, and the lack of step-parent rights created a sense of legal vertigo for American men. You could be a father because you were married even if you weren't the biological parent. You could be a stranger to children you raised for years because you weren't the biological parent. The only consistency was the financial obligation. As we approached the year 2000, this incoherence led to a rise in men simply opting out of the traditional family structure altogether, a trend that sociologists in 2026 are still analyzing as the fallout of the 90s system. But just as the decade was closing and the frustration was reaching a fever pitch, a technological and cultural shift occurred that changed the way these cases were fought forever. The 1990s had been the era of paper and landlines, but the year 2000 brought the birth of the digital trail. In the next part, we are going to look at the transition into the early 2000s and the rise of digital evidence in 1990s era cases. We will explore how the first saved emails and the earliest traces of internet activity began to appear in divorce court, turning private thoughts into public evidence. We will also dive into the case of a man in 1999 whose divorce was decided not by his testimony, but by his search history on an early version of Netscape. The era of privacy was ending, and the era of the digital divorce was being born. You won't believe how the first smoking gun emails changed the outcome of high-stakes custody battles. The year 1999 acted as a digital tripwire for the American male in the family court system. Until this point, evidence was physical, tangible, and often easily contained. A man's private thoughts were in a paper journal. His conversations were unrecorded landline calls. But as the decade closed, the emergence of personal computers and early internet service providers like AOL and Netscape introduced a new form of forensic evidence: the digital footprint. Imagine a man named Christopher in 1999. Christopher is an architect who has been using the family's new gateway computer to manage his firm's projects. He doesn't realize that every website he visits and every email he sends is being cached on a hard drive that is technically marital property. In a landmark historical trend from 1999, we began to see the introduction of computer forensics in high-stakes divorce cases. Christopher's ex-wife's legal team didn't just ask for bank statements. They subpoenaed the household computer. In the 1990s, most users had a fundamental misunderstanding of how digital data worked. They believed that hitting delete meant the information was gone. However, early forensic experts were beginning to show judges that deleted files could be recovered. For Christopher, an email sent to a friend venting about his frustrations with the judge, or a search history looking for out-of-state job opportunities, was suddenly printed out and presented as Exhibit A to prove he was either disrespectful of the court or planning to flee the jurisdiction. This was the birth of the digital smoking gun. Before the year 2000, if you wanted to prove a spouse was hiding assets, you had to hire a private investigator to follow them to a bank. In 1999, you just had to look at the browser cookies. Case studies from this era show that men were frequently caught off guard by the permanence of their digital communication. An AOL Instant Messenger chat logs could be used to demonstrate a man's late-night habits, which a custody evaluator would then use to argue that he was not maintaining a home environment suitable for a young child. The privacy that men had enjoyed for decades was evaporating in the glow of a CRT monitor. The step-by-step reality of the 1999 digital discovery process was invasive and often lopsided. Because men were more likely to be the primary users of home computers for work or hobbyist purposes in the late 90s, they were disproportionately vulnerable to this type of surveillance. Christopher would find his computer seized by a court order, taken to a lab and mirrored. Every draft of every email, every financial spreadsheet, and even his early participation in hobbyist chat rooms was scrutinized. If he had used the computer to research fathers' rights groups, like the ones we discussed in Part 7, the opposing counsel would frame this as evidence of a radicalized or combative mindset, rather than a man seeking support. Furthermore, we must examine the 1999 shift in how financial assets were tracked. This was the era of the E-Trade revolution. Men were beginning to day trade in the burgeoning tech market. Imagine Christopher had a secret online brokerage account, where he was trading stocks like Cisco or Microsoft. In the early 90s, hiding an account was as simple as getting the statement sent to a P.O. box. By 1999, the digital trail of bank transfers and online logins made this nearly impossible. The state's ability to find and freeze these assets became almost instantaneous. The historical trend was moving toward a glass house environment, where any attempt to shield a portion of one's earnings for a post-divorce life was flagged as fraudulent conveyance of assets. The potential outcomes for men who failed to adapt to this digital transparency were severe. Judges in 1999, many of whom were of a generation that barely understood how email worked, often viewed digital evidence with a mix of awe and suspicion. If a digital forensic report showed that Christopher had accessed a gambling website or an adult forum, the judge might not understand the nuance of casual internet use. They saw it through the lens of moral character, often leading to restricted visitation or lopsided property settlements. This was a decade where a man's reputation could be dismantled by a few kilobytes of data. This leads us to the rise of the electronic paper trail in child support enforcement. In the late 90s, the IRS and state agencies began to link their databases with unprecedented efficiency. If Christopher received a bonus or a tax refund, the system knew about it before the check was even printed. The 1990s was the final decade where a man could reasonably expect his financial life to be private from the state. By 1999, the automated income withholding orders were being processed by centralized clearinghouses. This meant that if Christopher moved from a job in New York to a job in Florida, his wage garnishment would often be active at the new company before his first day of work. The speed of the state was finally matching the speed of the digital age. However, the digital era also provided a new weapon for the resistance. As the year 2000 approached, men like Christopher began to use the internet to find something they had lacked for the entire decade: transparency. They started to compile databases of judges and their historical rulings. They shared the names of father-friendly forensic psychologists and warned each other about the tactical traps of specific law firms. The 1990s started with men isolated in their own tragedies and ended with the first iterations of the manosphere, a digital ecosystem where the collective knowledge of millions of divorced men was being synthesized. This collective intelligence led to the first major challenges against the standard of living math. Men began to use early spreadsheet software to build their own countermodels, proving that the court's calculations for alimony were mathematically impossible to sustain without causing the payer to fall below the poverty line. They brought these printouts to court, challenging the vocational experts with data-driven rebuttals. For Christopher, the same technology that had been used to surveil him was now being used to defend him. He could run his own 401k projections and show the court exactly how much money he would lose to taxes if a QDRO was executed poorly. The 1990s ended not with a whimper, but with a high-speed data transfer. The legal system was now a hybrid of old-world bias and new-world technology. The American father was no longer just a person in a courtroom. He was a profile in a database, a series of tax records, and a collection of recovered emails. The transition was complete. The 1990s had taken the traditional American family and put it through a high-pressure legal and digital shredder, leaving a generation of men to figure out how to rebuild their lives in a world that was always watching. But there is one final piece to this masterclass. Beyond the money, the custody, the protests, and the digital trails, there is the long-term legacy of the 1990s divorce. As we move into our final part, we are going to look at the 20-year aftermath. What happened to the children of the 1990s divorce? How did the laws of that decade shape the men of today? We will dive into the specific case studies of the now adult children who grew up in the every other weekend system and what they have to say about the fathers who were forced to the margins. We will also examine the final reckoning of the 1990s legal architects. This is the conclusion of the deep dive, the moment where we see if the crucible of the 90s produced a new kind of father or simply a permanent scar on the American psyche. The final reveal is about the future, and it starts now. The 20-year aftermath of the 1990s divorce era is not just a collection of old legal files. It is a living laboratory of social engineering that has shaped the modern American landscape in 2026. To understand the legacy, imagine a man named Justin. In 1995, Justin was 5 years old, watching his father Michael pack a suitcase and move into a one-bedroom apartment across town. Today, Justin is 36. He is part of the first generation to reach full adulthood after being raised almost entirely within the every other weekend system. The historical trends we see in Justin's generation are the direct result of the crucible we have explored in this masterclass. Justin doesn't just remember the divorce. He remembers the structural absence of his father, a void that was legally mandated and financially enforced. Case studies conducted in the mid-2010s and early 2020s looking back at children like Justin show a distinct pattern of potential outcomes. These adults often report a fragmented sense of family identity because the 1990s system prioritized the mother as the primary emotional anchor and the father as the financial provider. Many children grew up viewing their fathers as visitors or secondary figures. This led to what sociologists call the fatherhood deficit. Justin, now a father himself in 2026, often finds that he has no internal blueprint for how to be an involved, day-to-day parent because he only saw his father in 48-hour bursts. The 1990s legal system didn't just split households, it interrupted the multi-generational transfer of parenting knowledge. Now let's look at the financial legacy. The aggressive child support and lifestyle maintenance orders of the 1990s had a massive impact on the wealth-building capacity of American men. Michael, Justin's father, spent the decade of the 1990s, one of the greatest periods of economic expansion in U.S. history, transferring a significant portion of his gross income to a household he no longer lived in. While this ensured the children had a roof over their heads, it meant that Michael was unable to participate in the wealth-building opportunities of the era, such as the early tech boom or the real estate appreciation of the late 90s. As a result, in 2026, many of these 1990s-era fathers are reaching retirement age with almost no savings, having spent their prime earning years as a pass-through entity for state-mandated support. The step-by-step reality of this long-term depletion is visible in the current housing market. We see a significant number of men in their 60s and 70s who are still renters, or who are living in precarious financial situations because their 1990s divorce settlement stripped them of their primary residence and their retirement equity. This is the hidden poverty of the 1990s divorce. The system worked exactly as intended to prevent the children from falling into poverty in 1994, but it did so by ensuring the father would face financial instability in 2026. This has created a secondary burden on adult children like Justin, who now find themselves financially supporting the fathers that the 1990s system liquidated. Furthermore, we must address the legislative reckoning. The 1990s was the decade of the tender years ghost, but the 2000s and 2010s saw the rise of the shared parenting movement that we discussed in Part 7. By 2026, nearly 20 states have passed laws that create a rebuttable presumption of 50-50 custody. This change did not happen in a vacuum. It was driven by the data gathered from the failures of the 1990s. Lawmakers began to realize that the visitor dad model was contributing to higher rates of incarceration, drug use, and school dropouts among the children of those divorces. The 1990s served as the negative control group that proved fathers are not optional extras. The psychological legacy is perhaps the most profound. The 1990s created a culture of defensive fatherhood. Men who lived through that decade learned that their relationship with their children was a privilege granted by the state, not a right. This led to a historical trend of men being more cautious about entering marriage or having children in the first place. The declining birth rates and marriage rates we see in the 2020s can be traced, in part, to the observed experiences of the 1990s fathers. Younger men saw what happened to their uncles and fathers, the loss of assets, the loss of access, and the social stigma, and they performed a cold, rational risk assessment. The 1990s divorce system inadvertently acted as a massive deterrent to traditional family formation. However, there is also a legacy of resilience. The fathers who fought the system in the late 90s paved the way for the modern involvement of men in childcare. Today, in 2026, it is common to see fathers at school orientations, in pediatrician offices, and taking paternity leave. This was made possible by the 1990s pioneers who refused to accept the every other weekend status quo. They were the ones who sat through the biased MMPI-2 tests and challenged the vocational experts. They were the ones who insisted on staying in their children's lives even when the geography and the math were stacked against them. Michael might have only had Justin for 2 weekends a month, but he made those weekends count, and that persistence is what ultimately broke the back of the 1990s maternal default doctrine. Let's look at a final case study. The 1999 divorce of an airline pilot named David. David lost almost everything in the split, including his ability to see his 3 daughters more than twice a month. But David spent 20 years documenting every interaction, every payment, and every barrier put in his way. In 2021, when his eldest daughter got divorced, he was able to provide her husband with a manual on how to navigate the system effectively. This is the new reality. The men of the 1990s have become the grizzled veterans who are teaching the next generation how to avoid the traps they fell into. They have turned their trauma into a form of tribal knowledge that is now being shared across 2026 digital platforms. The 1990s divorce was a crucible. It was a decade where the laws were harsh, the math was brutal, and the cultural bias was rampant. It liquidated the wealth of a generation of men and displaced them from their homes. But it also proved, once and for all, that the father-child bond is not easily broken by a court order. The men who survived the 90s system and maintained relationships with their children are living proof that parenting is a biological imperative that transcends legal paperwork. As we conclude this deep dive masterclass, the final reveal is this. The 1990s divorce didn't just end marriages, it ended the era of the disposable father. The scars of that decade are visible in our laws, our bank accounts, and our families, but they serve as a permanent reminder of the value of the paternal presence. We have moved from a system of extraction to a system that is slowly, painfully moving toward equity. The 1990s was the dark night of the American father, but it was also the dawn of a new understanding of what it means to be a man in a modern family. If you thought the legal and financial traps of the 1990s were complex, you haven't seen the psychological warfare of the 2000s. We have spent 10 parts looking at the 90s, but the next decade brought something even more intense: the era of the high-conflict digital divorce. In our next masterclass series, we are going to dive into the years between 2000 and 2010. We will look at the rise of the smartphone as a surveillance tool, the birth of social media as a courtroom weapon, and how the 2008 financial crisis turned family court into a fight for literal survival. The game changed, the stakes got higher, and the tactics got dirtier. We are just getting started.